Hi, everyone. My name is Paul Runko, and I am the Director of Strategic Initiatives at Defending Education. There were some epic decisions by the Supreme Court this term, and some of that were pretty huge victories for parents. So, we wanted to do this episode today to make sure that parents knew all about what happened at the Supreme Court this term and what it means for them and their students. So, today we're going to break it all down for you, but we're going to leave all of the legal jargon at home. Here to help me explain is Defending Education's Vice President and Legal Fellow, Sarah Parshall Perry. Sarah, thanks for joining me.
Thank you for having me, Paul. I'm looking forward to talking about a very, very good Supreme Court term.
As am I. So, obviously, I think it's safe to assume that most parents aren't closely monitoring the Supreme Court. They're working a full-time job, taking kids to soccer practice, putting food on the table. But luckily for them, we are monitoring the Supreme Court. So before we get into the specifics, if anybody reads your ex posts or anything, you seem pretty excited about what happened at the Supreme Court this year. Tell us about sort of your general feeling from what's happened.
Well, we had a lot of high profile cases at the Supreme Court this term. Every time we go into another Supreme Court term, I always think, well, it can't conceivably be bigger than the term before. But we saw a giant term with huge culture war implication cases. In fact, we saw everything from ghost guns to Medicaid funding for abortion to religious charter schools to school choice and more. And in what I think has been a real sort of promising show of coalescence around the notion of textualist and originalist perspectives on the Supreme Court, we've got justices who seem very, very keen to look at the statute, to look at the Constitution, and to read nothing more into it than what is obviously there, supported by the text or by history and tradition of the Constitution and the rights therein themselves. So I think we saw a lot of good outcomes, even within the concept of anti-discrimination law, something that we focus on a lot here, Defending Education. We saw 2 unanimous decisions on whether or not individual plaintiffs who were of a particular class or in a particular environment had to meet a higher burden of proof to be able to succeed. And the short answer in both cases was no. So I think what we're seeing, with a few notable exceptions, is a return to common sense and strictly focusing on what the law says, not on which they think they want it to say.
We probably should have mentioned this at the top, and I sort of maybe we assume people know like what the Supreme Court is, but just like briefly, like the Supreme Court is like the top, like what they say goes is pretty much like how it works, right?
That's exactly it. And it is a creation itself of the actual Constitution of the United States. It is a creation from Article 3 of the Constitution that is the highest of all the federal courts in the land. And when they make a ruling on the interpretation of one law or another, that goes for every state and every federal jurisdiction in the country. Now, some of these particular cases are limited to individual fact patterns, but I think for purposes of what our parents will be most interested to learn about today, some of the outcomes in some of these very high profile cases are broad enough that all of the public schools implicated thereunder are really going to be impacted by what the Supreme Court held.
Great. So we're going to be talking about 3 main cases today that the Supreme Court made decisions on. Let's maybe lay the foundation before we do a deeper dive. So if you could tell us about those cases, maybe just what the name of the cases were, generally what they were about, and what was the outcome for parents. Why don't you just tell us a little bit about those cases?
Well, the biggest case of the term was arguably United States versus Scrimeti. That was a case challenging the constitutionality of Tennessee's so-called gender-affirming care ban for minors. And while in a related lawsuit, LW versus Scrimeti, parents had said that they had a constitutional right to achieve this experimental type of care for their minor children. That was not the question taken up by the Supreme Court. It was simply whether or not the court found it to be a violation of the Equal Protection Clause. And in the end, they said it was not. In a second very high profile case, one that I think we've written about extensively, that our parents have been very interested in, is Mahmoud versus Taylor. In fact, was there a constitutional right to opt out from mandatory curriculum, minor children from LGBTQ themed instructions when those particular mandatory instructional items conflicted with the sincerely held religious beliefs of a group of multi-faith parents? In the end, the Supreme Court said yes. And in yet another determination, in a case called AJT versus Osseo Area School Districts, the Supreme Court unanimously held that individuals who are seeking to recover, individuals with special needs, special disabilities who are protected in public education under Section 504 of the Rehabilitation Act or Title I of the Americans with Disabilities Act, they did not have to prove a higher standard in education than they would have to prove elsewhere to prove an actual discriminatory event. So a very good outcome for parents of students with special needs.
Thank you for laying that all out for us. We're going to talk a little bit more about those cases in a minute, but there was also something else that happened at the end of the Supreme Court term as it relates to women's sports. Can you tell parents about that?
Yeah, in what I think for many was a shocking turn of events, as we've watched litigation transpiring both in federal court in Maine between the Department of Justice and the state of Maine, and now between the Department of Justice and the California Department of Public Instruction and Education on the exact same thing, is the notion of whether or not trans-identified males can constitutionally and statutorily compete in women's sports. Well, we know Title IX of the Education Amendments of 1972 makes very clear the term sex indicates male and female. In fact, its implementing regulations make clear male or female, mother or father, boy or girl, each, both, either. These are binaries, right? The language itself indicates one versus the other, only two sexes. Of course, we all know that the Biden administration tried everything it could, 6 ways from Sunday, to expand the definition of sex to include gender identity, and was ultimately enjoined 11 times in federal court. It even went all the way to the Supreme Court, where in a procedural order, the Supreme Court said, you know what, we think the state of Tennessee that has enacted a particular law banning trans-identified males from competing in women's sports, we think they're going to succeed on the merits, so we're going to enjoin the rule there too, indicating that once these cases ultimately made it to the Supreme Court, we'd see a good outcome. Well, that time is now, because at the exact end of the term, before they got rid of all of the petitions on what's called the emergency docket, those were things about whether or not, for example, the Trump Department of Education had the authority to lay off a certain number of particular Department of Education employees, or whether or not universal injunctions were applicable across the country and were themselves legal. Before we got to those emergency petitions, one last cert grant, actually two, in two related cases that will very likely be consolidated, Hecox versus Little and West Virginia versus BPJ, two sports cases, one out of, again, West Virginia, one out of Montana, both of which the claim is separating sports by biological sex is a violation of Title IX and the Equal Protection Clause. Well, based on what we've seen from the justices and what we've seen in the lower federal courts, my hunch, I think, is pretty good that we'll see success come the fall 2025 term for women's sports.
Wow. I mean, that, like you said at the beginning, every term seems to get bigger and bigger and higher stakes. And so it certainly seems like they're setting up the next one for that. So we'll talk a little bit more about that as well towards the end. But thank you for telling us about that, Sarah. So I want to break down those three cases that you had mentioned earlier. I'll go a little bit out of order from your order and start with Mahmoud versus Taylor. We've heard a lot about it from parents, and I think there's a lot of questions kind of swirling out there. And so we want to answer some of those questions here today. So in that Mahmoud versus Taylor case, religious parents were affirmed in their right to opt their children out of certain aspects of school. What can they opt out of?
Yeah, that's a really good question. A couple of things I want to make clear right off the bat. First of all, the Supreme Court limited its decision within this context to LGBTQ themed curriculum. So we're not talking about questions of social emotional learning. We're not talking about critical race theory. We're not talking about ethnic studies. We're talking specifically about LGBTQ themed curriculum. And here's why. Because that is gender identitarianism and sexual orthodoxy and progressive sexual politics are really at the intersection of most major faith traditions. And that made it very, very simple for the Supreme Court to take an earlier case called Wisconsin versus Yoder, dating to 1972, in which the Supreme Court said specifically Wisconsin's interest in compulsory education could not outweigh the religious liberty rights of a group of Amish parents to raise their children according to the tenets of their faith. And in the Amish community back in the 1970s, the Supreme Court said specifically these individuals who reach the age of 14 go on to this agrarian lifestyle where they contribute to farm life and they contribute to construction and to agriculture. And that's important for the Amish way of life. In very much the same way, LGBTQ themed curriculum here in this particular case was challenged by a group of multi-faith parents. So these aren't just what we might think of as Protestant Christians. These were Orthodox, they were Jews, and they were also Muslims. And all of them challenged, saying specifically the notion of biological sex as being fixed and immutable and created by God is sort of endemic to, it is critical to our particular belief perspective. And we want to be able to direct the upbringing of our children, to inculcate the values of our faith without having our children indoctrinated by what we were seeing happening in Montgomery County public schools, and on very, very harsh questioning from some of the justices, including Justice Samuel Alito, who very pointedly asked attorney Alan Schoenfeld, who was the lawyer from Montgomery County Public Schools, why are you running away from what you clearly want to say? You have a perspective on LGBTQ themed ideas, and you want those children to share that perspective. That was a hard question for the attorney to answer. The entire curriculum was designed to, and I'm using quotes here, disrupt normative thinking. That is specifically what the curriculum said. And because of that, parents have a right of opt-out.
So you mentioned curriculum, and I think this is one of the things we're hearing sort of from the opposite side of, okay, great, now parents will be able to pick a far right curriculum in schools, but that's not the case, right?
No, it's not. And here's a really critical distinction, Paul. There was never at any point during the litigation a challenge to the curriculum itself. The parents never brought up a facial challenge to the curriculum. They didn't want to make decision on what is taught, and in fact could not have made that challenge, because any good lawyer worth their salt who's been in the education space knows parents don't have a cognizable constitutional interest in challenging curriculum. That's something better left to schools. They simply wanted the right of opt-out, and that is the critical distinction here. So any parent who says now, well, now I get a say in what's actually taught in my child's classroom, unfortunately, no, you don't.
So you mentioned the types of parents that were challenging, this policy and what was going on in this Maryland school district. So Muslims, or Orthodox Christians, Jewish parents. Parents are probably noticing that we're saying religious parents, and if you see our publications on this, we say religious parents. Do only religious parents have the ability to use this opt-out, or how does that work?
Yes, as of right now, it's religious parents. And again, this is a very limited holding because of a previous case, Wisconsin versus Yoder, that talks specifically about the right to direct a child's religious upbringing. Now, I'm going to say religious parents only for now, because the Supreme Court didn't get to that bigger question, whether there is a generalized right under the 14th Amendment, what we called, and what lawyers sort of cringe when we discuss, substantive due process. In other words, this goes to rights that are not directly laid out in the Constitution, but which the court has recognized for many instances in up to 100 years of jurisprudence actually exist. And the parenting right is one of those long recognized, but not directly enumerated rights. So we haven't gotten to the bigger question of what the 14th Amendment right looks like within public education. Now, what we may see this term as well, very significantly, there is a case in the 11th Circuit and there is a case in the First Circuit. And our organization is submitting amicus briefs in both, specifically challenging gender secrecy policies that socially transition minor children without parental consent or knowledge behind their parents' backs. Well, we believe that is a violation of the 14th Amendment parental right. Those two cases will both be going to the Supreme Court. One is already headed there on a petition for cert or a petition for a review. This may be the term that we just don't get clarity in women's sports, but we also get clarity in policies we've been tracking at Defending Education for many, many years, gender secrecy policies, and whether or not parents have a constitutional right to know how their child identifies.
Yeah, as a sidebar on that note, Defending Education has the list of school districts that have those types of policies. So if you are concerned that your school district is potentially hiding information about your students' transgender status at school, you can go to defendinged.org and you can find that list on our website. We're up to, over 1,000 school districts that have these policies in most of the states. So definitely check that out. Yeah. Back to the Mahmoud versus Taylor case. Kind of one last question for you, Sarah, before we move on. I don't think we can expect now schools to be like, okay, there was this Supreme Court decision. We're going to start sending opt-out forms to parents when we're going to be teaching these books and this curriculum, and we're going to let everybody know. And, so how do parents, this all sounds great, but how do parents actually activate this ruling to make sure that their child isn't being exposed to material in school that's against their family's religious beliefs?
Yeah, great question. So first of all, I will say right now, we've got an opt-out form on our website at defendinged.org. Specifically a form letter that you can utilize with your local school district or with your local school, specifically saying within the context of XYZ instruction, this is a conflict with my religious beliefs and I'm requesting an opt-out. This is formal notice. That's number one. But number two, you have a right under federal statutory law to examine your child's curriculum. And that's a right guaranteed to you under the Protection of Pupil Rights Amendments, the PPRA. Ask for examination of your child's curriculum, not just the science curriculum or the reproductive curriculum, where you have this sort of prototypical health class, the birds and the bees discussion. Ask for all of it. Ask to know exactly what your child will be taught. And from there, you can utilize our form pad opt-out for religious parents.
Yeah, that form, I can't recommend that sample letter enough that we have up on defendinged.org. It's also worth mentioning that one of the largest teachers unions in the country recently had their annual convention, and they talked about and I think even passed some sort of resolution about informing teachers of their rights around Mahmoud versus Taylor. And so it's important for parents to get clarity from their school districts about how they'll be implementing this. Yeah. Because there will be plenty of good actors that want to do right by the law, but then there will be some who maybe get influenced by the wrong people. So even if you don't end up submitting any sort of opt-out letter or letter to your school district, it's important at least to go ask the question of maybe your school board or your principal to see where your school district stands. So lots of action items for parents on that one. All right, let's move on to the first case you mentioned, Sarah, which is the U.S. versus Scrimeti. We have parents, all over the country, from Maine to California and Washington State down to Florida, and the ones in California and New York might be saying, okay, this is nice for Tennessee. They can uphold a ban on gender affirming care for minors, but I live in a bright blue state. Does this affect parents outside of Tennessee?
Unfortunately not, because the question was directly limited to whether or not the state legislature had the power to enact, in its reasoned judgment, a law restricting access to certain treatments for minors. So if you live in a blue state, and there are about 26 states now that have restricted these procedures in some form, whether hormones and chemicals or whether or not surgical interventions as well. About 26 or 27 states have already restricted these procedures if you live in a blue state where these procedures are still legal. Unfortunately, you're going to have to be doubly diligent with your own minor child, because there are clinicians now that are all too willing and eager to be able to start the process without parental consent. And yes, this happens. And where we see schools with so-called community schools that have school-based health clinics. I'm not talking your run-of-the-mill nurse's office who can assign a Tylenol or, have a child who's a little queasy from a stomach bug lay down in a dark room. These are actual community school health clinics that offer everything from behavioral and psychology therapy to chemical castration agents and birth control. So be diligent. Find out whether or not your school is a community school, whether or not there is a comprehensive health clinic within your actual school. Find out what their policy is about doling out medication without parental consent. So it requires doing homework, and it also requires voting with your feet. Elect people who in the end will get to the state legislature and make a determination to protect kids and not to harm them.
Yeah, to that point, parents, Defending Education has done extensive research on school-based health centers. So if you go to defendinged.org and use the search bar to type school-based health centers, you can find not only an investigative report of what these types of health clinics do, but we also have a running list of school districts that have some sort of, like Sarah said, you're not just, checking eyesight or, doing some sort of medication distribution, but also things like gender affirming care and whether your school district or not has that. So that's why that's super interesting to us, this US versus Scrimetti case, because so many school districts have started down this path of these community schools with the school-based health centers. And so it's not necessarily that, everything is bad here, but it definitely is an area where parents need to ask some questions. And this Supreme Court case seems to help them say, okay, at least we have the backing of law when we want to try to advocate for these positions, whether it be at my local school district or at my state.
Well, and you realize how close and how interconnected all of these issues are, because we start out with the Supreme Court case talking about indoctrination through LGBTQ themed curriculum specifically designed to change, quote, normative perspectives, to inculcate a particular worldview, to normalize certain behaviors, certain choices. That's where you start. And then what happens is you've got school gender secrecy policies that encourage social transitions. So kids who have been indoctrinated in 4, 5, 6-year-old ages are now being socially transitioned without parental input. And then you've got school community health clinics, which are actually doling out medication to facilitate that process. And then we go ultimately into the full-on medicalization of whether or not these individuals go on to have surgical interventions, which are, as we know, irrevocable, and they are life-altering. And in fact, recently, the Federal Trade Commission just held a very long day's worth of hearings specifically related to deceptive trade practices within the gender medicine industry. Individuals who were performing surgeries without informed consent, individuals who were providing chemical castration agents without parental consent. So this is an entire pipeline. This is ultimately the school to medicine gender identity pipeline. And you see how right at the center of it, right at the center of this maelstrom, are cases that are coming out of the Supreme Court. So for me as a lawyer, but also as a mother, it's an exciting time to be alive and be watching what happens at the court next.
All right, so the last one you mentioned is AJT versus Osseo Area School District. We could just touch on this one briefly. What does this mean for parents who have children with disabilities?
Yeah, great case. So in this particular case, the Supreme Court was considering whether schools had to essentially consider particular levels of obligations when they had students with special needs. It's about a student who had epilepsy, who had a very difficult time going to school during daylight hours because the light and the classroom stimulus would often very much trigger her episodes of seizures. But this was a unanimous decision from Chief Justice John Roberts, joined by all of the justices, and they rejected a standard. The school had said, well, this particular plaintiff didn't prove that we were in reckless disregard, and that was the terminology, which is why you note my very fancy formalized use of air quotes here. We were in reckless disregard of her special education needs. And the Supreme Court said, wait a minute, that language doesn't appear anywhere in Section 504 of the Rehabilitation Act or the Americans with Disabilities Act. You're reading into it. And in fact, by forcing individuals with special needs to meet a higher burden, you're actually discriminating against them. So Section 504 and the ADA also apply not just within school contexts, but outside, in, for example, public accommodations. In fact, in a case called Cummings versus Premier Rehab Keller, we saw recently, about 2 terms ago, a specific case about a woman who was visually impaired and whether or not those particular practices applied to her, whether or not a physical therapy clinic had met its burden of proof. So Section 504, the ADA don't just apply in school, they apply outside of school, but it a great outcome. All the justices agreed. Listen, within the concept of school, individuals with special needs, with disabilities, don't have to meet a higher burden of proof than they would have to meet elsewhere. It was a unanimous decision and great for any parent who has a child with special needs. I had 2 of them, and this was a great outcome. I would have benefited from it significantly if my little boys were still that age in school.
Yeah, and for parents who might be watching or listening with children with special needs, Defending Education, we don't necessarily specialize in special education, but if you're having some sort of issue, perhaps with your school or school district, or you're curious about a particular part of special needs education, like, please reach out to us. Go to defendinged.org, contact us, and if we can't help you, we can find the right people that could potentially address your issue. So parents who might be listening, any parent really, but those of you specifically in this issue area, feel free to reach out to us about that. So Sarah, this, I guess, coming to some final thoughts here, it sounds like this was a pretty big year for the Supreme Court in terms of what it did for parents. What should parents be taking away, like, at a high level from what's gone on?
Well, I think if there's anything to take, it is ultimately this. Number one, it requires parents who have courage, conviction, and a steel spine. It took a group of parents, bold parents in Montgomery County Public Schools, to get a case all the way to the Supreme Court. It's taking a bold mother in the 11th Circuit and bold parents in the First Circuit in 2 gender secrecy cases who were ultimately also going to file for review in front of the Supreme Court. If there is any area of public law right now, and what we're seeing the Supreme Court take on, as somebody who has been in this field for many years, I cannot believe how much school law is being taken up by the Supreme Court. It's an invigorating time to be alive, but it also indicates that sometimes these are battles that are won inch by inch, not mile by mile. And it may take a while, but for you guys, the encouragement is the Supreme Court's listening. America is listening. We are enacting good laws. We are electing good legislators. We are electing good school board members. And it just goes to show the power of every single American parent when they come together, when they coalesce around the idea that education should be high quality and value neutral for every American student. And we know the reality is, Paul, as much as we love our charter schools and our parochial schools and our homeschoolers, we also know most parents send their kids to public school. I'm a product of public education. I served at the United States Department of Education. My children were a product of public education. I feel passionately about it. I know that you do. Everyone at Defending Education does. So we hear you guys. And it's an encouraging day to be an American parent because the people at the highest levels of power are listening.
I think that's such an important takeaway because, like I mentioned, we have plenty of parents from what I would maybe consider an anti-parent state. But, the Mahmoud versus Taylor was Maryland. I mean, it's hard to find states that are maybe much more on the opposite side of us than them. So if they can achieve what they did there, I really think anything is possible. And you're right, it does take courage to do this. And so we know it's not easy to do, and that's why Defending Education is here to help support you in the courage that you might need, or parents might need, or grandparents might need, or even just concerned citizens who care about education might need. So hope this conversation has been helpful to those of you who are watching, and that you were able to take away something from this episode today. We'll continue to keep an eye on all of the things that the Supreme Court is doing. The best way to get alerts and to keep up with what we're looking at is to sign up for our email newsletter. You can do that by going on DefendingEd.org. Just go down a few scrolls and you can find the sign up for our email list. Again, that's DefendingEd.org for all the updates on everything, but specifically the Supreme Court. Lastly, I can't stress enough how important what Sarah mentioned about the opt-out letter, the sample opt-out letter that we have for religious parents opting their children out of those sex and gender-related materials in school. Please go check that out. Again, you can find it on the homepage of defendinged.org. Really great resource that we've been hearing from a lot of parents on, and a lot of parents have been sharing it with other parents. So definitely worth checking out. Lastly, please like this video, share it with a friend, share it with a fellow parent that you think might benefit from what was discussed today. Sarah, thanks as always for joining me. Always a pleasure.
Thank you, Paul. Always a pleasure as well. And thanks for asking such astute questions.
All right, we will see you next time, everyone.